After is very urgency. The High Court has closed the hearing without objection, my lord. The High Court allowed without objection, my lord. The matter is very urgent.
We will take it up on Monday, not today. Let's see if the office objections are complied with. Fresh matters will come, in the list. Objections are complied with, all fresh matters will come.
Matter is very urgent, my lord.
So what to do?
Early date may be disturbed.
Is it numbered?
Yes, FR number, FR number.
Please get it numbered. Once it is numbered, it will come. Yes, all memos to the court officer, call the list. Adjournment is not required, a short list.
Second list.
Number 1.
One urgent.
My lord, serial number 7.
Some Monday. Being spoken to for urgent.
One, sir.
For respondent in this matter.
Yes. Who is respondent?
Respondent, I am the respondent.
List is matter in the month of January.
Number, sir.
List is matter in the month of January. It is submitted that the negotiations are going on. Next, why the memo is moved then?
Respondent is moved, my lordship. In the meantime, we are trying to settle the matters. I'm ready to take action.
Compliance of the order 50 extend ಮಾಡ್ಕೋಬೇಕು ಆ ಶೆಡ್ಯೂಲ್ ಅನ್ನು ವ್ಯತ್ಯಾಸ ಇದೆಯಂತೆ ನೆಕ್ಸ್ಟ್ ಅದು ಕಂಪ್ಲೀಟ್
He is appearing for respondent for the petitioner kindly have this matter after 2 weeks. Now some questions are there in the schedule to enter into the compromise.
This also in the month of January at the request of both the parties.
My lord, serial number 7, my lord. Serial number 7, the connected matter was listed yesterday, my lord. It is posted to 20th. It may be posted with the
number. Is a number. List along with that.
That already been connected, my lord, since I'm for the petitioner in this matter. It has been connected yesterday. So interim order has to be. If it is
List along with so and so. Interim order only granted is extended.
Lordship
The
kindly.
serial number 19, my lord, I appear for the respondent.
for the petitioner, my
The noting in the order sheet is the matter should be listed in the month of January, and the matter has been moved, my lord, without notice to us.
ready to address the argument.
19.
Whole problem. Now everybody is like, if the court is saying it looks harsh, but that's what they're doing. Every day, 40, 50, 60 memos. Why they move? They don't even tell that already matter is adjourned. Then court has to see all the memos in the afternoon for 45 minutes. And then this is the result. Today already one memo moved and sought adjournment. Now this without even, it's not about addressing the arguments. When the matter is adjourned to January, why should you move a memo? What is the reason? In your presence, the matter is adjourned, is it not? Then why did you move a memo?
Office objection was complaint, my lordship, since the matter was in the urgency regarding the child custody, my lord.
No, for complying with the office objections, I have posted it to January. No. List is matter in the month of January.
My lordship, next week, any date may be
No.
given, my lordship.
No.
Full request, my lord.
No.
Lordship kindly.
My lord, serial number 13, I am appear for the respondent. I seek an adjournment for 2 weeks because I need to file my objection, my lord. The notice was served on the previous counsel who was appearing in the trial court. Now I have been come on record in the trial court and
What objections in a writ petition?
my lord, they have sought for the custody of the child, my lord, and they have said that they want the interim custody of the child for the entire weekend, all the public holidays.
I'll be looking at the material that's available on the.
For me to appreciate them, I have to look into the material, my lord. There are several cases which have been stemmed out of this matrimonial dispute, my lord.
There is an interim order in this or not?
My lord, there is already an order for interim custody on weekends from 10 a.m. to 8 a.m.
In this case?
In this case, nothing, my lord.
So if they've come, it's for the petitioner to argue. If required, we will adjourn. Yes.
Lordship kindly. Lord, serial number 21.
First list, my lord, serial number 21. K group matrimony. 31020, my lord.
Wait.
Comfortable with that.
What is that? Serial number?
Serial number
22.
22, no, sorry, ma, 22. No.
Hmm.
WhatsApp kindly, I'm not comfortable with the fracture. WhatsApp kindly.
Inform the other side.
Yeah, already.
Huh?
And for the respondents in serial number 22.
They have himself informed
List,
to
list this matter after 2 weeks.
3 weeks now.
List it in the month of January.
Please, ma'am.
Lordship kind,
No, ma'am. Kindly take it
Allah,
after
interim
2
order
weeks,
absolutely
madam.
is.
They are asking for vacating the custody of the child, madam. I have only interim custody. I'm
That-
only going and meeting.
List this matter on 20th. Interim order earlier granted is extended till now.
20th this month, Malta.
Yes.
My Malta, it is very difficult task to manage the sustained action. Therefore, I start time. Otherwise, I will
This is a
not-
matter in the month of January. Interim order earlier granted is extended till then.
My lord,
The
you
law-
have to go meet the child only on Fridays, my lord. They have got interim order for that also. You are not able to meet the child.
So what is to be done?
My lord, kindly take it up in 20.
Now, if a short date is given, he will say, I have a fracture, I have problem. If a long date is given, you have a problem. What the court is supposed to do?
Hey, himself
December
take
first
time.
week, my lord. December any first week, my lord.
This is a matter on 10th of December.
Your Lordship kindly, Lord. Lord, serial number 21.
Yes.
Lord, last time, Lord, it has been advised us to make the other side, to make a home, and we should go there. Then he sought a time at least in 15 days to make a home, and then he will take us to their home, matrimonial home.
We are searching for the house and we need 15 more days time
Mhm.
because we have to finalize the house. He's searching, he started searching. So we are finalizing the house. We need 15 days time for that to finalize the house. So please have a date in December first week, my lord.
Lord, December 2nd week,
List this matter
or December 2nd week.
on December 11th.
Lord, 2nd week.
I think 11th is second week.
Please, much, sorry, Lord, sorry.
December 11th.
Please.
Till, please wait. Till
Please.
such time, the earlier arrangement that the father, all the three of them can meet at the convenience.
Please.
I mean, throughout the week as per the convenience of the parties.
Okay, Lord. They are meeting it, Lord. They are meeting it.
Second list, my lord, seal number 13.
Yes.
16.
Call second list.
Second list, page-wise adjournment, list number, page number 2, serial number 4 to 6. Page number 3, serial number 7 to 9. Page number 4, serial number 10 to 13.
13, my lord, seal number 13. Matter was supposed to be listed yesterday. Over, my lords, the matter is listed today.
So what?
The learned counsel, my lords, who is appearing for the respondent, is held up in the trial courts, my lords, in Mangalore because there are 2 cross examinations. Hence, he is not able to come to Mangalore today. He was there yesterday. Therefore, he requested.
We will hear the matter. Yes, next.
That's on 19th, my lords.
Serial number, page number 5, serial number 14 to 20.
Serial number 14, my lords. It may be taken after 2 weeks. I've informed the respondent, my lords.
You have an interim order. You have an interim order.
No.
It will not be extended even if it is there.
It is not there, my lord.
Yes, list this matter in the month of January.
Serial number 19,
Yes.
to be taken up in the month of January.
Why?
Because all the evidences in.
What evidence is required in a RPFC?
Finally.
Still, what will be there? The big thing. Have you informed the other side? Without informing the other side, you tell the court to take the matter in the month of January. List this matter on 4th of December. No further adjournments will be granted.
Serial number 16, madam. So also 16 in the first list. I missed that list. Technically, I had during the first week of December, my lord. There is no interim order.
Have you informed the other side?
No, I promised the
Death
court.
or like
16.
Date may be.
List in the month of January.
My
No,
lords,
instead of January, it could be.
No, because
could
it's
it be
not
had
possible
during
for
the
the
first
court,
week?
every matter, half of the list
I
adjournments.
just want to construct one more sentence of submission, that I am in the serious midst of advising my party to settle this course, which has arisen aftermath of the decree for divorce. That's all. I am in serious, first week of December, my lord.
List the matter on 4th.
my lords, serial number 11 and 11.1, list 1, please, my lords.
For the petitioner in 11.1, the office objects to be complied with. Matter was listed yesterday before Court Hall 40A and 1 week time has been granted to comply the office objections. And I'm the respondent in 11, my lords, and also a matter is pending
Where
for
is the other
meeting.
side?
I'm the
You
petitioner.
have no objection.
Lords,
My lord,
in
interim
terms-
order at least may be granted, my lord.
Huh?
Mother is not able to see her children. Even if she has visitation rights, they are not letting her
There is the
exercise.
matter. Yes, next.
My lord, serial number 10, my lord, some for the respondent, there is an interim order.
This.
List number 1, serial number 10, there is an
Hmm.
interim order, for the respondent, my lords. There are certain citations to be provided by me, my lords. Kindly have it in the first week of December.
Just it in the month of January.
Grateful.
Interim order earlier granted is extended.
Minute, serial number 2, serial number 16, list number 2, minute.
There is no procedure once in list 1, list 2. List 2 is where? Which number?
Serial number 16, minute. I am for the respondent, minute.
Yes.
Minute, I seek a week's time, minute, because I need to produce the assets and liabilities.
This also in the month of January, interim order earlier granted is extended.
Okay, grateful.
Okay. List number 1 for orders matter, serial number 1.
And for the
Court to
petitioner,
begin.
for the petitioner, I filed memo for withdrawal, my lord. Petitioner willing to withdraw this as per memo filed. May be permitted to withdraw this.
Who died?
I'm for the petitioner.
No, what is this memo? I didn't understand. It says the respondent Jyoti came to the wife of the petitioner, died on account of attack.
Yes, my lord. At page number 2, my lord. Order sheet is final orders.
The petitioners before this court are Rohit Kumar versus Jyoti. The respondent wife is no more.
Yes, my lord.
The memo is filed stating that the respondent wife is no more. And nothing survives for consideration in this petition. And the petitioner wants to withdraw the petition according to the dismissed as withdrawn.
Serial number
Much
2,
obliged.
T. Nehru for petitioner. D. Kuppaswamy.
I am for the respondent, Your Lordship.
I am for petitioner, kindly seek time for 1 week.
Your Lordship, I am having objection. In spite of having visitation right order from the trial court, the petitioner is not allowing me to visit the child who is only 4 years. And they have come here for setting aside the order. And for last 1 year, I have not seen the child. Only in last first date of hearing.
Please understand, even on the last occasion also, there is no representation on behalf of the petitioner.
File was misplaced, that's why I'm seeking 1 week.
No, this court has not granted any interim order. What is the difficulty for you to execute that order?
Yes, Your Lordship, that is what we will file. We are going to file the contempt against them.
And as far as this case is concerned, when there is no interim order, you can't insist for, hearing of this
Your
matter.
Lordship, they are just abusing the process of the law. First of all, first date they have not attended. Second day they have come and said they have not bought the file. This is the third day, same submission, Your Lordship.
Is this matter in the month of February? The petitioner is repeatedly asking for adjournments. There is no interim order in this case. The respondents are at liberty to execute the order.
Obliged, Your Lordship.
Serial number 3.
Appear for the petitioner, my lord.
Bindu, you.
My lord, on 12/7/2025, your lordship held that service to the respondent, despite repeatedly done by my party, has held sufficient. So lordship may take it up for hearing, my lord.
Yes.
Page number 11, the impugned order. Had been granted maintenance to the tune of rupees 10,000 per month. I had claimed 2,50,000. 17 is the operative portion.
Why you require 2,50,000 per month?
My lord, I suffer from knee
Show the-
joint displacement.
Show your statement of assets and liabilities, what are the expenditures?
Page number 90, my lord.
Page number?
90.
Yes.
In terms of the detailed expenses, your lordship had asked me to file an affidavit. It has been filed, my lord. In terms of dated 4/8/2025.
Husband says his income is 90,000 per month. Wife says, I want a house rent of 45,000.
My lord, they have not disclosed their entirety of
What
the.
is to be done now?
I'll just make two submissions.
Also not filed the full assets, statement of assets and
I placed an
liabilities.
affidavit before this court, my lord.
Whatever it is, now considering the income at 90,000, only this court can grant maintenance.
My lord, 10,000 is on the lower end of
And
this.
please
Yes,
understand
ma'am.
what the court is saying. I said, considering 90,000 as his income, court can consider the maintenance. That's what I'm saying.
Please, my lord, please.
Please come. Agreed with the order passed in I number 2 in MC number 249 of 2019 dated 15 December 2023. The wife is before this court seeking enhancement of the maintenance amount. Parties are referred to as wife and husband for the sake of convenience. Who filed the MC?
I filed the MC.
Wife had filed the
Wife.
MC seeking divorce. In that, she filed an IA under section 24 of the Hindu Marriage Act, seeking interim maintenance of rupees 2,50,000. It's a case of the wife that the husband is a BE graduate and he has his own fabrication industry. He also has interior designing business. He's having several properties in and around Chennai and also one flat worth rupees 2 crores at Udupi. He has agriculture lands. Further, four-wheelers and two-wheelers, and his income is 10 lakhs per month. The respondent has filed his objections. It is stated that he is earning rupees 70,000 per month as his salary. Apart from salary, he does not have any other income. And is paying EMI of an amount of rupees 60,000. The court, by order impugned, when he said 70,000, why the court is saying it is 90,000?
No, 70,000, he states is his expenses.
No. Come to the earning rupees 70,000 per month.
My lord, in his assets and liabilities, page number 97. General monthly expenses of the respondent. He claims that is 70,000.
I'm asking about the income. Where do you get that? In which page?
In his affidavit.
Page number?
Page number 98.
Monthly income 90,000. No.
100, my lord.
90,000, not
90,000.
70,000. The court, by order impugned, had granted maintenance of 10,000. The court has observed that the affidavit of assets and liabilities filed by the petitioner, filed by the wife, discloses that she is undergraduate, suffering from lumbar disc disease, migraine, etc. According to her, she is a homemaker and do not have independent source of income. though it is stated that he is owning a partner in Vishal Glazes Private Limited, but no such evidence is brought on record. And according to the husband, his salary is 90,000 per month. The court observes that the wife has not produced any document to show that the husband is the owner of Vishal Group of companies. Further, there are no material to establish that the husband is the owner of the joint family properties. Immediately, husband has borrowed the home loan and purchased an apartment. Considering all this, the court has granted 10,000 as maintenance. When counsel appearing for the petition submits that the husband has come before the court with suppression of material facts. All the facts are not disclosed before the court. As he owns four-wheelers, that itself shows the financial capacity of the husband. She is suffering with several ailments and she is not qualified, and she has no source of income. The amount of rupees 10,000 that is awarded by the court is not just and reasonable. This court on 2/7/2025, this court has passed an order that as per the post treasurer, notice the respondent has returned as unclaimed amounts to deemed service of notice. Having heard the land counsel for the petitioner peruse entire material on record, the expenditure as placed by the petitioner before this court, stating that she requires 2,50,000, and she has given a huge list of 45,000 rent and other expenditure. As per the evidence available on record, the husband's salary is 90,000. When a husband's salary is 90,000, question of granting 45,000 towards rental expenses will not arise. Though so many things are stated, as rightly observed by the family court, nothing has been proved by no material is placed to substantiate the contention that his income is 10 lakhs per month. In these circumstances, considering the salary of 90,000 of the husband, this court deems it appropriate to grant an amount of rupees 22,000 as maintenance. Accordingly, the order dated so and so is modified, and the amount of maintenance of 10,000 that is granted is enhanced to 22,000.
Maybe stated from the date of application, my lord.
And the same has to be filed from the date of application. Yes.
Serial number 4, Arun Govindraj for petitioner, Geeta Menon.
Respondent. Your husband's petition challenging an order of the family court dismissing his application. Just to give a brief background, there are 3 proceedings pending before the family court. The restitution petition filed by the husband in the year 2015, custody petition filed by the husband in the year 2015, and a divorce petition filed by the wife in the year 2018, if I'm not mistaken, 17. Lord, I have come on record recently in the matter before the family court. I have advised my client that divorce, there's no point now after 10 years to resist divorce. All that he wants, Lord, is time with his daughter. She is now 13 years old. The daughter there's some reluctance on her part to interact with him and his parents. Separation has taken place about 13 years ago, where the child was.
She's hardly like.
We've been having visitation throughout, but only in public places. Until 2023, my lord, daughter was absolutely comfortable with the father and grandparents. During the course of proceedings, some photographs seems to have been produced before the family court to show that the relationship is good between the father and the child. From that day onwards, there is reluctance. I'm only requesting, my lord, I understand if I'm we seek your lordship's
What is
indulgence.
this writ petition about?
The writ petition, my lord, is challenging an order dismissing my application. In the divorce proceedings, the wife has filed an application seeking money from me on the ground that I had made her spend 46 lakhs. That application was not pressed until my cross-examination was concluded. After my cross-examination is concluded, she files an application. I want to place on record material now to show that I have transferred money to his account. And she produces, and to third party for expenses, third parties. She produces only, my lord, tranches of payments made without producing the entire bank statement. Therefore, I file an application before the family court. Please direct her to produce the entire statement because that will reflect the transfers made by me to her. The family court says you cannot ask the wife to produce evidence to support your case, and on that ground dismisses my application.
Well, let's see that.
Yes. IA number 16, annexure G.
Page number.
It's at page number 125. The reasons are from page 135. Married. From going through the proceedings in this case, it is clear that the petition in MC 738, 135 is filed by the husband under section 32 of the Divorce Act for restitution of conjugal rights and issuance of direction against the respondent wife to return to the matrimonial home and live with the petitioner. On the contrary, the respondent wife has filed divorce petition in MC 5326 of 2017, and both the cases are clubbed together. In the objections to the restitution of conjugal rights petition filed by the petitioner husband, the respondent wife has claimed permanent alimony of 5 crores. From going through the evidence of PW1, it is clear that several questions were asked to PW1 regarding the expenses borne by the respondent wife. In page number 45 of the deposition, questions were asked and PW1 stated that he does not remember what were the credit cards he was having in the year 2011, and he further stated that he does not remember if the wife has paid the credit card bill of 1,10,000 on 28/11/2011. He further stated that he does not remember the exact amount which was paid by the respondent wife with reference to the question of payment of 1,85,239 towards holiday tour. So also in page 47, questions were asked with reference to the amount spent by the respondent for scanning purposes, security deposit of 2,50,000 deposited by the respondent, 1 lakh for other expenses, and 75,000 for expenses of the child. So several questions were asked with reference to monetary transactions. Therefore, it is clear that there is dispute with reference to monetary transaction between the petitioner and the respondent. Under IA 15, the respondent wife wants to produce email correspondence and WhatsApp correspondence exchange between them and some bank statements.
So where is your application? IA affidavit?
IA 16 is at page 116 of my application. Annexure E. For the reasons stated in the accompanying affidavit, it is most humbly prayed that this honorable court may be pleased to direct the petitioner to produce and make discovery on oath documents which are in her possession and power relating to her bank statements for the period 22/8/2009 to 31/12/2014 for account number so-and-so at ICICI Bank, account number so-and-so at HDFC Bank, and account number so-and-so at HDFC Bank, and produce the entire SMS chat histories from 22/8/2009 to 31/12/2014 instead of the extracts of the chat in the interest of justice and equity. At para 4 and 5, I have stated, Manoj, that she has produced only selective transactions from the bank account.
No, according
Yes.
to you, you have transferred some amount.
Yes, ma'am.
That she is not showing.
She's not showing.
Because if it is, you have transferred it from your account, if you produce your account, it will be
But
sufficient.
absolutely, but what happened is this. Her application is filed on 18 September 2018, seeking reimbursement of some amount which she says she has transferred to me.
No, but
My
once-
cross-examination concludes in 2023.
No, there are two things. One, either you produce it, or because of in view of this application, let him produce.
My lord, I know, let him produce, but my lord, I'm just pass on, I'll just give my, these are the cross-examination, my lord, the dates are not correct, what my team has submitted. The application was filed in 2018. If your lordship sees the evidence of the
Application is filed in the year 2018.
Yes, my lord, give me, and he files his objections. Now in GNWC, your lordship may see where he was cross-examined. Your lordship may see page 15, in page
Objections
15.
are filed in the year 2019.
19.
When
Now
was the
your-
order passed?
Order is passed. Now, what had happened, my lord, that IA was kept in abeyance, saying that it will be decided along with the main petition because evidence had to be let in. That's why in 2019 itself, it was said that it will be decided along with the main petition. It's not that we do not press it. Now, your lordship may see in the GNWC case, page 15 of this book compilation which I've given, which is the cross-examination of the petitioner in this case. Now, this cross-examination happened on 17/1/2018. My lord, your lordship may see the last line on page 15. It is not true to suggest that the respondent had paid the premium on 28/2/2014. I had transferred 6 lakhs in the respondent's account from the said account and she has paid. If required, I can produce the receipt for having paid the premium.
Where
Now,
is that?
that is page 16. Page 15 and 16, your lordship will get off the ink page, not the internal page. Internal page is 28.
Yes, 28 I'm looking at.
Yes, last line, my lord. It is not true to suggest that the respondent had paid the premium on 28 to your lordship. Got it, my lord? I had transferred 6 lakhs to the respondent's account from the said account. She has paid. If required, I can produce the receipt for having paid the premium. Now, my lord, this is what he has said in 2018. Similar questions have been posed. Now, your lordship may see in the MC case, divorce case, if your lordship sees the deposition, your lordship may first just take a look at page 31, that is internal, in page 31, internal page 27 of that deposition. Exhibit P22, which he has produced. He has produced sample bank statements. This evidence, he files it in 2021. Now he produces sample bank statements. Now your lordship may see the various questions posed. Your lordship will first get at page 36.
Yes.
First para 7. I will produce the documents to show that I have also paid the rent and the maintenance. Then your lordship may see, insofar as that premium is concerned, your lordship may see in fact, I'll just take the relevant pages, my lord. Page 20, page 50. Now I cannot say how much money I have paid, that is para 23. Now I cannot say how much amount I paid to the respondent wife, but I can produce the documents. He keeps saying everywhere that I can produce the documents. Then your lordship may see page 53.
Yes.
I had withdrawn that, your lordship will get 6th line from the bottom. It is false to suggest that I have not paid any amount towards the salary of nanny and maid. I had withdrawn from my account and given the amounts to the respondent. I can produce the bank statements. Then your lordship may see the next page, 54, para 26. I have produced some of documents to show that I paid a substantial amount towards domestic affairs, and I can produce additional documents if required. Then your lordship may see page 56.
Yes.
I can produce additional documents if required. Then your lordship, now that premium amount, your lordship, which he has mentioned in his affidavit, your lordship will get a reference to it at page 58.
Yes.
Para 30, it starts, I had transferred approximately rupees 10 lakhs towards her account towards payment of policy premium, which is contrary to what he says in his affidavit and in the GNWC. I can produce the bank statement to show the transfer of 10 lakhs in total. Now, this is the only 2 incidents which he says he needs, that this money has been transferred. Now, he keeps saying that he will produce, but he doesn't choose to produce. He closes his side. Now, my lord, the first IA which they have filed against is where in my evidence, I filed order 8, rule 1A to produce the additional documents for marking of documents. Now, that documents, that IA is allowed, documents have been marked and she's being subjected to cross-examination. So that IA becomes infructuous. Now, as far as the other order is concerned, my lord, when he himself is aware from 2018 that even in cross-examination, when questions are, and he says, I will produce, he doesn't produce in GNWC. He produces only sample bank statements in his evidence in 2021. In the cross-examination until 2024, he says, I will produce, but he doesn't produce. Now he cannot compel me right from the day of marriage till, because in the affidavit, only 2 instances are narrated. No other instances are narrated. He doesn't produce. Now he cannot compel me in my evidence that I should produce all these documents as evidence. Therefore, my submission is, my lord, the family court rightly rejected his application.
Let me make this, your lordship may kindly note these dates. 18/9/2018 is the date of application filed by the wife, seeking reimbursement of certain payments she says she has made to the husband or on his behalf. On 12/9/2019, I filed my objections to the application.
Yes.
Sorry, I filed my objections.
It's 12/9/19.
On 2/9.
12/9/2019.
Yes, my lord. On 2/9/2020, a submission is made for the wife that this application where she is seeking reimbursement may be taken up along with the main matter. Do not decide the application now. Thereafter, my evidence is led, cross-examination is completed. My cross-examination mode is completed on 19/12/2023. 19/12/2023.
No, even at that point of time also.
Yes.
Repeatedly you are saying that if necessary, I'll produce.
Yes,
If necessary,
but there was no occasion because she had not produced any document on record.
Ultimately,
yes,
the court will take up that matter. All the evidence that you let in before the court, that will be taken into consideration at that point of time.
No, not all documents she had produced before the court until my only one submission.
You are asserting a fact.
Yes.
For that, why should the other produce?
I understand, my lord. Therefore, may I make this request? Kindly permit me to reopen my statement only for the purpose of producing these bank statements. Because when I'm confronting her with my bank statements, she's refusing to acknowledge or even recognize the bank statement. I don't know, this is not my statement. I cannot admit the statement. Transfers from my account to her account.
What about the statement? Once you say, towards the premium, I have given 6 lakhs. Towards the premium, I have paid 10 lakhs.
No, the entire transaction is born from my bank statement. Look, the next date I want to bring to your lordship's notice is 19/12/23. My cross-examination is concluded. The bank statements produced by the respondent is on 24/1/2024. After my cross-examination is concluded, then they want to bring additional documents on record.
When you are filing an IA, you could as well file an IA saying that all my documents take on record.
My stage of my cross-examination was over. My stage of my evidence was closed. After this 19/12/2019.
The light of these facts, when the light of these facts, instead of filing this kind of an application, putting, the
we could have filed, I could have filed an application to reopen my, that has not been done. May I make this request? Kindly permit me to file an application only to produce bank statements, nothing else, my lord, to show the transfers from me to her.
That will.
He always had an option to recall and reopen.
Please go.
Only request, my lord, is this is a 2015 matter.
It will be disposed of.
Yes, please, my
No unnecessary adjournments. Only it will be open for, for those documents. That's it.
Right now,
page number?
Right now, cross-examination of RW1 is going on in the process.
The
125.
Agreed to the orders passed on IA number
16.
Yours is 16.
16.
IA number 16 in MC number 738 of 2015 and MC number 5326 of 2017 dated 23rd August 2024. The husband is before this court. Parties are referred to as husband and wife, for the sake of convenience. The husband has filed MC 738 of 2015 seeking restitution of conjugal rights, and wife had filed MC number 5326 of 2017 seeking divorce. In the year 2018, the wife has filed an application
under the Domestic Violence Act, IA number 13.
Under section 20, that was section 23 of the Domestic Violence Act. seeking seeking a direction to the husband to pay a sum of rupees 53,77,263 with interest at 18% per annum till realization of being the loss of income and monetary loss caused by the husband to the wife by forcing the wife to use her earnings, thereby causing losses in the interest of justice and equity. The court has kept this IA in abeyance and proceeded with the main matter. To this IA, the husband has filed objections on 12/9/2019. Thereafter, the evidence has started. In the evidence, when it is suggested to the husband with regard to the expenses, with regard to the premium and other household expenses, which the wife had spent, it is a case of the husband that for everything he has, he can produce the bank statement, he can produce the documents in support of his case. Thereafter, after the evidence of the cross-examination of the husband is completed, wife had filed a IA number 15. IA number 15.
Along with her evidence. Along with her evidence.
Along with her evidence, she wants to produce the
And mark additional.
bank statements
And other documents.
and other
chats.
documents in support of IA number 18. What is that
15,
IA?
15.
15.
IA number 50. The court has allowed that application.
That time I filed IA 16 and both were decided together.
Then at that time, the husband has filed IA number 16. According to the husband, the wife is not filing the entire bank statement. If the entire bank statement is filed, all the facts will come to light. The husband had filed IA number 16, seeking the wife to file
At page 129.
bank statements for the period of 22/8/2009 to 31/12/2019.
14.
2014, in respect of ICICI bank account, HDFC bank account, two HDFC
Two
bank
HDFC.
accounts, and to produce entire SMS chat histories. Where will be these histories of 22/8/2009 to 31/12?
These iMessages, they both have it, even we have it.
31/12/2014 instead of extracts of the chart. The court, by order impugned, had allowed the application filed by the wife and dismissed the application filed by the husband. While dismissing the application, the court has observed that
We have para 17.
it is a case of the husband that he has deposited the amount, then he can produce his own account statement. Therefore, with reference to those transactions, there is no need for issuance of directions against the wife. The court observed that the relief sought by both parties is dissolution of marriage or restitution of conjugal rights with reference to grant of permanent alimony, financial status of the parties is required to be considered. Therefore, there is no need for issuance of direction against the respondent wife to produce bank statements from 2009. If the documents sought to be produced under I number 15 or admitted in evidence, then the petitioner husband will get chance to cross-examine the respondent wife on each document. Therefore, it will not cause any injustice to the petitioner husband. Even though during the cross-examination of RW1, if it is proved that she has withheld the documents which are material, then adverse inference can be drawn against her. Hence, the court had dismissed the application and felt that there is no need to issue direction to the wife to produce the documents. Assailing the same, the husband is before this court. Learned counsel appearing to the husband submits that these documents are marked, this application is filed after the cross-examination of the husband is completed. As she is in a pick and choose manner, only a part of the transactions that she is filing, hence they have filed the said application. By filing those documents, no prejudice would be caused to the wife. The court ought to have allowed the application. Next paragraph. Learned counsel appearing for the respondent, wife submits that this application is filed by the wife in the year 2018. Husband has filed his objections in the year 2019. Then the counsel has placed before this court the cross-examination of the husband. In that, she has drawn the attention of the court to the cross-examination and submits that. On several occasions, when the questions were put to the husband, it is stated that if it is necessary, he will produce the document, bank statement, the additional documents. In such event, he would have produced the documents which are in his possession. And question of asking the wife to produce these documents was not required, and the court has rightly dismissed the petition. Further, it is submitted that these petitions are of the year 15 and 18. MC filed for restitution is of the year 15, and MC filed for divorce is of the year 18. 17. And these matters are, and now your evidence is at to, RW1's evidence?
Cross-examination is going on. 3 days.
RW1 cross-examination is going on. At this stage, the petitioner, husband, may not be permitted. At this stage, question of placing these documents before the court would not arise. Next para. It is submitted that the petition, the husband had enough opportunity right from 2018. Next para. Having heard the counsels on either side, there is the material on record. The only issue here is, according to the wife, she had paid certain amounts, and she's seeking. She's seeking a direction to the husband to give those amounts back. According to the husband, towards the premium for the insurance policy, whatever the amount that is paid by the wife, he has already given her, and for other expenses also, the husband has been paying the amount, and he has a bank statement and other record. If that is the case, the husband would have produced the same instead of asking the wife to produce the documents. The court was right in dismissing the application as filed by the petitioner, that's IA number 16. However, balancing the interests of both the parties and also for putting a quietus to the litigation, this court deems it appropriate to pass the following order. Order dated, the order in IA number 16 in MC number so and so, dated 23rd August 2024 is modified. And the petitioner is at liberty, the petitioner husband is at liberty to produce the documents, and only for that purpose the evidence of the petitioner shall be reopened. And the court, for number 2, the court shall not adjourn the matter and grant unnecessary adjournments, as these 2 matters are old matters and have to be disposed of at the earliest. Accordingly.
So, Blythe.
Still number 5 to 7 adjourned. Still number 8. Pramod R for petitioner. Yes, Ramakrishna Gowda.
Yes.
Permitted to produce the translated copies of the judgment.
Translated copy of?
Judgment, my lord.
Where is the other side?
Other side has been served, they have not appeared.
Any urgency in this?
No urgency, it's only the fact that the modification of the order, my lord. The question is, a visiting rights has been granted to me to see my child.
There is no representation on behalf of the respondent. As a final opportunity, list this matter on 27th.
I will file it in the register.
Take that, the translated copy of the impugned order
Yes.
is filed with the petitioner. Yes, next.
Serial number 9,
For the respondent.
Who moved?
Respondent has moved.
Petitioner in this case, my lord.
Yes.
The husband, my lord. I'm paying the regularly 13,000 rupees to the.
Forget about paying, please come to the, both of you are present before the court, will hear the matter.
Next date of hearing.
No next date of hearing.
2025 matter, I have some information I have to discuss with my client.
No, I think the earlier also.
No, my
this has
lord,
come,
even
the
till
same
the-
submissions
according
were
to
made.
this honorable court,
One
I am
minute,
paying
1 minute.
13,000 rupees
This
every
is matter,
regular without
after the vacation,
bail,
this
my
is matter on, every time you're seeking the adjournment.
My lord, actually, I am paying
Please
13,000 rupees, my
understand,
lord.
this is an IA. This is an IA, interlocutory order.
Yes.
Interlocutory order, there is nothing like a final hearing for this.
Yes, please, my lord.
So he is here, very limited issue, we will decide.
There is
Yes.
no problem to her, my lord. I am paying regularly 13,000 rupees, my lord.
So if 1 minute to please tell the court, because you are paying regularly, forever this matter will be pending before. the
Next date
court.
of hearing, definitely I will place my.
What is the difficulty today?
No, my lord, actually, I will discuss some matter, subject with my client. Because of that, I am paying the adjournment because that.
What subject, please tell the court. Court also understand what is that great subject you want to discuss.
My
with
lord,
your client.
actually matter is even till today petitioner respondent, they are going to husband and wife. There is no problem at all. Only problem between the property between the elder son and petitioner.
So
Because of that,
all
I'm.
these things can be decided in the pending case before the trial court.
Yes.
No matter needs to be pending here. For that, no instructions are required. Please proceed with the matter.
At least next date, next week, I will place my.
List this matter on 20th. No further adjournment will be granted. This shall be reflected in the cause list.
Serial number 10 adjourned, serial number 11.
At least, my lord.
You
24th.
have
May-
a choice, Mr.
20
Khan.
please.
I will take it up on Monday.
24th, my lord, next
Take
Monday.
this matter on Monday. List this matter on Monday. In the second list. Yes,
24th, my lord.
Monday. It is coming up on Monday.
20.
At least 24th, please, my lord.
Either it will come on 20th or on Monday. Choice is yours.
Any date.
Serial number 10
20th.
adjourned, 11. Anshumani A for petitioner.
Respondent 11 and petitioner 11.1, please.
Appear for petitioner in serial number 11.
11 is by the mother.
By the mother, please.
11.1 is by the father.
Father, please.
So where is the impugned order? Let us
Impugned
see.
order is same in both.
That's what-
Operative
that I know.
parties
Where
at
is that page number?
page 29, my lord. Operative parties at page 29.
Please read.
My lord, IA number 5 filed by the respondent mother under section 12 of the Guardians and Wards Act is dismissed. However, the respondent mother is permitted to avail visitation rights to the children daily 1 hour between 6 p.m. to 7 p.m. during working days and between 3 p.m. to 6 p.m. during weekends, on Saturday and Sunday, and on other general holidays in the place of residence of the children without affecting the activities of the children. The respondent mother can visit the children in any other place other than the place of residence of the children with the consent of the petitioner and to the choice of the children. In other words, both the petitioner and respondent may accommodate the children to visit their mother at mutually agreed place of their convenience without affecting their activities. The respondent mother shall not take the children outside the premises where they have mutually agreed.
What is
to.
the age of the children?
7, 6.5 years.
6 years.
6.10 years.
No, there are 2 children.
Yes, ma'am.
6 years and
Twins, my lord.
They're twin boys.
They are twins.
6.5 years.
6.5 years.
So from how long the children are with the father?
My lord, that is the issue, my lord. I'll convince, my lord may take page 34.
You can tell us.
As
how
they're
from-
together, my lord. In between what happened? Both the mother, husband and children were living together. In between what happens, my lord? He throws the mother outside, out of the house. After the order, my lord. I have made the brief synopsis, may I place on record.
Take that.
My lords, I have not filed my objections. My lords, if I may take my 30 seconds of my lord's time. What has happened is after the petition is filed, she has filed a domestic violence petition and entered the house when she is not even in the house during the entire period. And my lords, the writ petitions by himself that they have filed, where she has claimed that she has taken a house on rent. The writ petition itself speaks for itself. Her own writ petition, my lords, that
Children of 6 years, 7 years, what is the difficulty there with the mother?
my lords, the mother has some psychological issues, which is also been captured in documents. I'll have to place it before my lords, because what has happened is, like my learned friend is suggesting that they're living together, that is completely false. She has left the house way back in 2024. She has taken a house on rent. She is living close by to the house.
2024 is not
No,
way
my lords,
back, it's
my lords,
just 1 year.
there are multiple locations subsequent to which she has gone. They've entire lifetime they've lived in Bangalore. She goes to Nellore, files an FIR in Nellore, drags him all the way to Nellore. The police there, and there are gundas there. 15 members attack him. The council who's gone with him to Nellore to the police station, fears for his life, runs away. She has been put into his car.